All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. Thank you for appearing before us. I think this is one where you guys agreed to appear at a district case, so we especially thank you for that. We like traveling. It's nice sometimes to just stay at home and we can pay attention to other matters as well. So again, thank you for traveling here. We'll go on and call the docket. You've received notification of the amount of time each side has, and of course the appellants have an additional 5 minutes for rebuttal, so you don't say, you don't have to ask for any reservation of additional time. You guys got it already, or the appellants have it already. So with that, we'll go on and call the docket. 07-24-00032-SCV. And who's here for the appellant?
David Strain, Assistant.
Thank you. And for the appellees?
Thank you, Your Honor, Thomas Michelle and Mr. Kelly Pools.
Very good. And I think you indicated, Mr. Michelle, you're going to be doing all the argument, correct?
Correct, Your Honor.
Okay, very good. Thank you. Yes, Lord.
Thank you, Joe. So this is a premises liability case against TxDOT. It concerns a difference in lane height on a concrete road because the lanes were made of concrete slabs and one of them had sunk because of turned out a stream or spring of water under the road had undermined it, unknown to TxDOT, and it sunk, and the evidence was undisputed that this could occur suddenly. So we know in this case the difference in lane height was 2 13/16 at most, because my friends on the other side hired an expert, Lee Jackson, who went out and measured it. And the way he measured it, he was an expert, but all he did was take measurements. He went and drilled holes through an asphalt wedge that TxDOT, after this accident, had placed to make sort of a ramp, so it wouldn't be such a sheer drop or lip to climb. And so he did that by drilling holes, many holes in this asphalt. And then he took a 6-inch nail and took a tape measure and took a photograph of those two together showing it was 6 inches. He then put the nail in each hole and measured the difference so that we could know what the difference in lane height was. And he sent an email to Mr. Smithson's lawyers and said, here's what I have found making these measurements, 1/4 of an inch to 2 13/16. They came back and said, well, it looks like some of these photographs, there's not that much showing. So why isn't it more than 2 13/16? And he replied by saying, no, those went in the joint between the slabs. So when you have two concrete slabs, there's going to be where they meet, that's a joint. And he said those don't show the depth. Now, they were able to get the photographs into evidence because they offered them and I didn't object. That was fine. But when I attempted to offer the emails, they objected and were sustained. However, the contents of those emails came in during the testimony of my expert, Jeff Milburn, who testified adversely.
He didn't take any measurements, did he?
No, ma'am, he did not. He just testified to what was in the emails, explaining why some of them in the photographs indicated more than 2 13/16. So it is in this case clear that the difference in lane height, according to these measurements, which is a physical fact, this is not an opinion, is less than 3 inches. In addition, and I've just been handed a demonstrative handout that y'all now have up there from the other side. This is a photograph of a white paint line next to the condition. The white paint line is undisputed to be 4 inches. If you take something like a pen and you hold it up and carefully measure the black part and then realize that the white part is flat, you can see that that the difference in lane height is just over half the 4-inch paint line. So we have two actual ways to physically measure this condition.
So I want to make sure I understand your argument. Your argument is that it's conclusive that the separation was less than 3 inches?
That's correct. And under the City of Keller Supreme Court case, that conclusive evidence is dispositive in this case because
even though Mr. Smithson eyeballed it to be 5 inches,
well, he said 4 to 5 inches.
4 to 5.
So we can't
The jury
assume,
gets to take that into account, don't they?
well, first of all, we can't assume that it's 5 inches because they have the burden of proof. So if that was evidence, the most it would be 4 inches. He says 4 to 5, but he hasn't proved that. But under the City of Keller case, which is it has a many holdings in it, but a couple of them, the Supreme Court said that evidence cannot be taken out of context. Evidence must be disregarded if incompetent, and evidence must be disregarded if other evidence conclusively establishes the opposite physical fact. And what we have here in this photograph conclusively establishes the opposite physical fact. And what we have in the photographs and the email from Mr. Jackson conclusively establishes the measurements. So just to give an example, suppose Mr. Smithson were to say, I'm 7 feet tall. But then someone came up here and measured me and took a picture of the measurement that said I was 5'10".
What was the space between the insertions of the nails? Or the nails?
They're shown, they're in the photo, in the evidence. And there are many of them, but I don't have that number.
They were not within an inch, as far as the record shows. They could have been within yards.
I don't think yards, but looking at the picture, they seem to be every 2 feet or something like that.
Every 2 feet. Would
I mean, I'm just guessing.
Would they conclusively prove that there was not a drop of more than 3 inches between that 2 feet, 3 feet?
Well, first of all, not from those photographs, but from the photograph that they have from the, I think it's the video showing the entire uneven lane condition, shows it tapering at each end, but in the center is equal. It doesn't show anything going like that. So that's positive evidence. And secondly, they have the burden of proof. I don't have the burden of proof. So if there was there's no evidence of that, which means the court cannot assume it. In other words, they have to prove if there was such a thing.
At the point that Mr. Smithson eyeballed it and said 5 inches, did the individual driving the nail through the asphalt check it at the same exact point or within a foot of that exact point?
No one knows what that point is because that's not in the record. And again, they have the burden of proving it. So anything they don't prove doesn't work against me. I don't have the burden to prove that fact.
Well, but you're showing the evidence was conclusive. I would think you've got the burden to show the conclusive nature of the evidence based upon the record.
What is conclusive is what we see in the photograph. And what the evidence shows, the only evidence that
wouldn't you have to show that the measurement was taken at the point that Mr. Smithson was eyeballing it to show that this photograph and his measurement is conclusive? Otherwise, we don't know, because we don't know if they were looking at two different places.
I don't think I have that burden. I think that burden is on the plaintiff because the plaintiff has the burden of proof. And what the Supreme Court in Keller said was that when you have physical evidence that conclusively shows something, then that's what you have to look at. And the other thing I would
look
point
back to your analogy or your example that you used just a minute ago. If somebody comes into court and says, I'm 7 feet tall, the way we would prove it is we would measure the entire 7 foot of the person and say they're either 7 foot tall or they're not. What you appear to be arguing is to say we can measure from the floor to their knee and infer that they're not 7 feet tall, but that's not conclusive evidence.
I think part of the issue is who has the burden of proof. And when the Supreme Court says conclusive, that is not shifting the burden of proof. The court is just saying, what evidence do you have? And does it show a conclusive physical fact? And I'd also like to point out that Mr. Smithson does not know what part of this uneven lane condition he encountered. He doesn't know because he
Does that
admitted.
make a difference if it's a, does that make a difference if it's a special defect?
Well, it makes a difference because only a condition that proximately caused the accident can be something TxDOT can be liable for. And it's a special defect determination depends upon the effect on the ability of a vehicle to travel down the road. So if he didn't come in contact with part of that area, then it cannot be part of the special defect determination, and TxDOT cannot be liable for it. Just like a pothole that he didn't hit, and he says he hits, well, they argue he hits potholes. There's no evidence of that. But he was looking over his shoulder, and all he knows is the motorcycle began to wobble, and he wakes up in the ambulance. So my point is, even if he pointed to an area that was 4 to 5 inches, there's no evidence that's the area that caused the accident.
Curiously, there was reference in the briefs to sparks after he fell. There's sparks going off, and that would indicate some type of metal coming in contact with the roadway. Were there any pictures of scrape marks on the roadway to help indicate where he fell?
No, Your Honor. And again, they had the burden of introducing any of that evidence.
Okay. And your argument with regard to the measurements, the difference in height, that pertains to your argument that the Supreme Court has pretty much said, as a matter of law, if it's less than 3 inches, the defect is less than 3 inches, tough noogies, you don't win.
Well, I don't know if I'm pretty sure they didn't use that exact
They were
phrase.
thinking tough noogies, but
Well, and I would like to point out that the special defect determination issue is something that's in the statute, but it makes me wonder, why would TxDOT ever be considered have an invitee duty? Because invitee duties are usually addressed to like Walmart or for profit, and licensee duties are directed for people who are on the premises for their own purposes. So it would seem to me this should always be a licensee duty. I've never argued that in a point of issue, but it's not just a got you, guess what? Here's, what the legislature is doing for TxDOT. It could very well be, we'd be better off if it didn't, 022 wasn't there. But I think that's interesting about the Reed case is that the syllabus says 2 to 3 inches. The body of the opinion says 2 inches, and the syllabus doesn't matter. But the Supreme Court made a mistake, and I don't get to get up and say that very often, but I can here because they came along and admitted it, or at least corrected the mistake in the paper decision, in which they cite Reed as a 2 to 3 inch difference in lane height not being a special defect. So they say Reed says 2 to 3 inches. And if you look at the Court of Appeals opinion,
just curiously, let's say there is a separation in the lanes. The lanes are going this way. There's a separation of this much between the lanes. It's a drop down of 2 inches, 2.5 inches, less than 3 inches, 2 7/8 inches. It's big enough for a motorcycle's front tire to get in it, and it channels that motorcycle's front tire. This is a hypothetical. I'm not talking about that.
Okay, I get
And
it.
it channels that front tire. And maybe the gap is wide enough to get the back tire. It's channeling the motorcycle. And that motorcycle's going down 60 miles an hour. It hits that channel. You're saying it's tough because the drop was only less than 3 inches, even though it effectively channeled the motorcycle's direction, which resulted in a crash.
That sounds a little bit like Sonnenfeld, which this court decided.
But Sonnenfeld is deeper, so we don't get into that
Right.
according to you.
And Sonnenfeld never mentioned Reed because the conditions were very different.
Okay,
in
but
Reed.
no, in my hypothetical, you're saying in that situation, tough. It's not a special defect.
Well, all I can say is what the Supreme Court said.
And that's especially so given that a car could have gone over it while a motorcycle couldn't have.
Well, then my head's spinning now with 3 or 4 issues
Yeah.
going. I'm like they do in the searches, we're getting all the little plates going. So,
That's the fun about oral argument. We can ask you this stuff.
well, I enjoy it. I actually enjoy it. I'm just a broke down old trial lawyer, but I do enjoy arguing in the Court of Appeals occasionally. So to answer your question, the Supreme Court in the paper decision said that a drop down of a pencil length deep, I think it was either several hundred feet or several hundred yards, I don't remember, but it was 6 inches wide, was not a special defect. That does not mean that TxDOT can't be found liable with a situation like that. They can if they prove the elements that the duty requires under the law. Is it a licensee or an invitee duty? So they have to prove the Supreme Court and the legislature have made the decision that they're going to impose these different duties in premises cases. That goes back to before Texas was a state, before the United States was a country, and back to ancient England. And anything that has survived that long must have public policy reasons. We may not all agree with them, but if this case is not a special defect, which is not, then they have to apply the other duty. And there was no evidence that TxDOT had actual knowledge. And in
Before we go
addition,
to actual knowledge, is there any evidence in the record as to how wide the rut or the groove was?
well, there wasn't a groove. There was
dropped.
just a difference in lane height.
Well, is the difference in lane heights or uneven lanes, is that the same thing as lane separation?
No. So we got 2 ideas. Lane separation would be like this. Like I should do it like that. That's a lane separation. Difference in lane height would be like this. And this is what we had here.
Okay, and Sonnenfeld involved lane separation.
That's right. That was 4 to 5 inches. And let's see, that was 4 to 5 inches, 200 feet long and 6 to 7 inches wide. So that was why this court didn't mention Reed, because it was a very different factual situation.
Well, the plaintiff in this case, Mr. Smithson, distinguishes the Reed case by saying that it's not disputed that the defect here was not due to normal deterioration as it was in Reed.
And the Supreme Court in paper said it doesn't matter, because in that case, if I remember it, the city had gone out and done something and it wasn't normal deterioration. And the Court of Appeals said, oh, it's different because of that. And the Supreme Court said, no, it's a condition. It doesn't matter how it got there, other than it might prove actual knowledge or might not. Here, clearly did not cause by anything TxDOT did.
So you were going to discuss the actual knowledge or lack of, I guess.
There's none. And so there's no evidence of actual knowledge. In addition, under York, the Supreme Court said, if the other side asks for and gets a special defect charge over the objection of the defendant or a submission of charge in proper form, which I did, and they don't get an essential jury finding of, say, actual knowledge, then the case is not sent back, it's reversed and rendered. But in this case, I can also say there's no evidence that TxDOT had any knowledge of any condition out here.
What about the red paint?
The red paint would go to the issue of the time notice rule. It has nothing to do with the special defect determination or who put it there. And in fact, TxDOT employee testified they didn't put it there. It was probably the police that put it there. And there's no evidence of who put it there, when it was put there, how long it was put there.
Does the existence of special defect, does that just change the standard from licensee to invitee?
That's correct.
Okay, so let's assume it's a special defect. What is the obligation of an invitee to correct or warn things that they actually knew of or should have known of?
Well, you said invitee.
The
but
obligation to the invitee.
Yeah.
The property owner would
Excuse
be,
me, yeah.
would be the duty to, well, there are four elements in it, and it
But the
basically,
notice part, the knowledge notice, what is that?
that element is the TxDOT to have actual knowledge of the danger of the condition.
It's not, or should have known,
You know, I'm sorry, I'm getting myself confused. It is a should have known standard.
okay. Was that discussed in the should have known, was the should have known argument related to the red line, basically? There's red paint out there, is that how they get should have known, or is there any evidence that they were relying on, in your view, that they suggested,
I don't,
indicated should have known?
I don't remember what they argued to the jury at this point.
Well, that wouldn't be evidence.
Right, and so I don't know, they may have put on evidence during the trial, but I don't know what their position was from the evidence, and I don't remember what they said about that, so.
How long after the accident was the photograph of the area with the red paint taken?
I don't know. I don't think there's any evidence of showing that, so then again, they were saying it's faded. That's whether the faded part, and I'd like to point out that this, that the marks, that the black line in this picture, which is the original picture, is actually much wider than the black line and what they have done transposing. They'll have to explain this to you, but they're not, it doesn't look the same, but they're talking about the red paint, red something that's rubbed up against the side, not this bright red, but this up here. And I see I'm out of time. Thank you.
Thank you, counsel. You do have 5-minute rebuttal. Ms. Michelle, whenever you're ready.
May it please the court. Thank you for having us here this morning.
So should motorcycles just be not allowed to be on highways?
You know, it might be a good idea. They are definitely dangerous things, but they are legal. They're authorized, and the Supreme Court and this court have held that motorcycles are entitled to the same type of protection that motor vehicles are, and bicycles as well. So I think the issue here is that the state of Texas has adopted it, and the TxDOT specifically testified both from Mr. Tron and Mr. Martin that it's their affirmative duty to make these roads safe, including for motorcycles. They didn't shy away from that. Mr. Tron, who was the head engineer for North Tarrant County, said it's their duty, it's their responsibility, and their obligation to repair and make the roadway safe. So until the law is changed on that, Your Honor, that is the state of the law with regard to motorcycles.
And your position is that in determining special defects, you look at the ordinary traveler or something along that line, and that would include not just cars, but motorcycles and bicycles and anybody else who uses that.
Yes, sir. Yes, Your Honor. Absolutely. That's what the paper case was a bicycle case. I will say we do distinguish paper, because this is not just several things I got to correct. Mr. Milburn was the state's expert who testified that the measurements that were not admitted into evidence, they were.
Well, there's no objection, though, to his testimony that he relied upon the email, and that information from the email was in evidence, wasn't it?
By hearsay, through the expert, yes,
There was no objection.
that is
so-
correct. There was no objection. However, and that leads to my underlying deal. We did cite coastal, which is, you don't need to have an objection if it's going to be speculation. And that's why I'm going back a little bit, Your Honor. Is Mr. Milburn, their expert, himself testified that the plaintiff's expert measured it wrong. That was right out of the box. So he's relying, and as this court is, for appellant's counsel, articulated that there was no testimony about where it was measured, what depth, what part, all those problems. So Mr. Milburn's testifying based it on excluded evidence, no methodology about where, when, or how those measurements were taken. Just a a hearsay email on his own testimony said he measured it wrong. That's our reason why we say it's no evidence at all and no objection was required under coastal, because it's just sheer speculation, and he himself condemned the measurement practice of plaintiff's own expert. A couple things I think we need to look at is, and the state does a very good job. It wants to piecemeal, and it wants to carve up in isolated little sections of what the evidence really is. We clearly have the uneven drop. Mr. Chief Justice, you pointed out the testimony of the plaintiff. What's even more overwhelming and very compelling, and rarely do you get this type of testimony, where you have the independent police officer come out and say that the defect in the road caused the accident. Also, their own assistant supervisor came out and testified that the roadway was not even, the defect in the roadway was so severe that he wouldn't even warn about it. He would shut it down.
But what does that say about their knowledge? That if it's so severe, I mean, do we attribute that they had notice about it? I mean, it happened suddenly. That's the theory that they tried to articulate. They didn't have any actual evidence of that. They had the opinion of Mr. Milburn, who said, I think it could have happened quickly. Well, you point out in your brief that that there was a void, there was an underground spring or water.
That's correct. And
So how would they have known?
they wouldn't. That was what they were articulating, was when we're pointing out in the brief, that was their position. But what we're saying, there's a couple things. One is the unevenness. Two are the two potholes. So it's a combination of effects. That's why I'm saying we're not parsing it. It's a multiple, and that's for the jury to determine.
Well,
Right,
was there
that's a
any
jury
evidence
question.
that he hit the pothole?
We have evidence that he came into that area. I think as much as anything is possible. A lot of times he testified as to what happened. I think it's the jury to make the determination about, they can look at the video, they can look at the evidence, they can look at the pictures of the potholes and say it's a combination of effects that caused it.
Was there
I
any
think it's almost-
evidence in the record as to the diameter of the potholes?
I don't know that there was, other than the visual pictures. You can see that the potholes are deep. And there's two, there's one in the middle of where he could have hit that, and two at the end of it, which could have finished him off. Once again, Your Honor, you're right. I don't know that you would ever get testimony more than what he could describe about how he hit that, the police officer coming out and looking at it, and then the TxDOT's own employee coming out there saying, this defect is so severe, we got to shut it down.
Well, the police officer didn't mention anything about potholes
He did not.
in his report or in his testimony.
He did not. That is correct.
When were the photographs taken?
I have deduced, Your Honor, that what I can tell from where the picture was taken, I believe the picture had to be taken the day after the accident.
How do we know from the record?
I'll
about
tell you
that?
why. The friends went out the day after and took a picture. That's where that video comes from. And TxDOT's exhibit number defendants 14 is their log report that shows they repaired and asphalted over that area the day after. So the accident happened on the evening of the 16th. The pictures would have had to been taken on the 17th in order to get it, because TxDOT paved it over the next day on the 18th. So the only testimony is that they were out there that day in between. That picture and that spray paint, at least my feeling, Your Honor, is could have only existed during that one day. Otherwise, it was paved over. You've seen the pictures of the pave over in the record. They came in their log show, they came out the next day. So the only way that picture of the red paint could have been there would have been the day after the accident, because it was dark in the evening by the time that happens. The next day is when they went out to the site. Our client went out there as well, and that's when he made his observations. So that's
So
the time.
Pictures the day after, that's where you see the red paint.
Yes, sir. Yes, Your Honor.
Okay, and that's, you also see the black, I guess, is that the tar that they used or to fill the gap, or?
You know, to clarify, I know it kind of looks like when you see the picture, the unevenness, it looks like it's a black deal. I think that's the darkness of the shadow of the lanes. What you'll see in later pictures where they came out, they They did it in two stages, the repair. They came out, the first stage was immediately to remedy the situation as quickly as Mr. Martin had testified that they went out and asphalted it very quickly to even it out. And as we know, because you're dealing with concrete and asphalt, putting over, that's a temporary fix. They can go up there, they can lay they can lay the asphalt very quickly, repair it, which he determined as a temporary fix. And then later on, they went out there a second.
So these are prefix,
Yes,
prefix.
that is prefix, because otherwise, I'm deducing that. Otherwise, if you'll see in other pictures that they had blacktopped it, and by their own records, they did that on the 18th. So about a day and a half later, TxDOT was out there quickly and repaired it. So
And are there any pictures in the record of this area before the accident?
no,
Okay.
there are not.
Is there any direct testimony with regard to who painted that red?
No,
Okay,
I would not say there's any direct
Yeah.
testimony. Yes,
you're making inferences that it's the TxDOT did it,
yes.
and what is that based on?
Mr. Martin, the person in charge for the repair out there, testified that that TxDOT has red spray paint, that they use red spray paint, and that they use red spray paint to spray defective roadways.
Did he testify they used red spray paint to mark this?
He did not testify that he had no knowledge himself. He said, as far as he knows, TxDOT did not use red spray paint to mark that. Once again, there was no other evidence that nobody else used red spray paint or had red spray paint. And the evidence is undisputed that TxDOT had the red spray paint and used red spray paint to mark defective areas.
My wife has shown me in her remodeling of the houses that there are many shades of green, there are many shades of white, there are many shades of black, and there's many shades of red. Was there any comparison of the red spray paint used by TxDOT against the red spray paint on the surface in this picture?
I don't believe so. The best we could get was, and quite frankly, very fortunate to get that picture we did get, right? Because it was repaired. We had that one moment in time to get that picture, and fortunately, they went out to that site the day after and got that picture. If you see, the reason why we did this, the top demonstrative is the plaintiff's exhibit number 7, and it's bait stamped. So you can, because there's multiple pictures, you can identify exactly which one.
Let's say we agree with you.
Yes, sir.
And we say, okay, at least there is some evidence, there's some testimony that would allow a reasonable juror to infer that that's the department's spray paint. What evidence do we have that that was the department's spray paint that was put down before the accident, other than the fact that it's fading in part?
I think 2 parts, Your Honor. I think the first part is that the accident happened in the evening of the 16th. The picture has to be taken on the 17th. TxDOT wasn't out there till the 18th. That would conclude to me that the sprayed paint had to be there at the time of the accident. There's no other way it could have gotten there. Number 2, and that's why we did those demonstrative exhibits. All we did was take the picture and make it a PDF and show you the contrast between the red line on, I call on the right-hand side, the lower part, and just copy digitally and post it. So just for dramatic purposes, so you could see the contrast about the length of time that the red paint had been worn off almost completely. It's a little bit faded on that top white part, whereas on the bottom part, it's fully red. It's the same red paint, just transposed for visualization purposes to see the white.
Well, here's my concern. My concern is we're having to draw a bunch of inferences about that period of time. We're having to infer that it's the department spray paint. We're having to infer that
When,
That department wasn't out there until the 18th, and we're having to infer that it hadn't been done at an earlier point in time because the spray paint was flaking off or disappearing. And my reading of what we can infer is we can't stack inferences on top of each other. And so I'm trying to work with that part and trying to understand how we have a timeline based on the evidence.
I understand, and those are obviously observations that I think are appropriate and an issue for the court. The way I would say is this is not your normal inference upon inference analysis, which we know that case law. I think there's some concrete foundations we can rely on. One is the timing, right? Two, Mr. Martin himself said, and his logs show they didn't go out there till the 18th. Those are some concrete, hardcore, timing issues that we're not really relying inferences. I think where the inferences kick in, but I think once again, they're good. And we're based with the state of the record. TxDOT had 31 employees. They didn't call anybody. They didn't call anybody out there to dispute that whatsoever.
Well, it wasn't their burden.
It wasn't their burden. However, once the evidence is put on that Mr. Martin testifies, we have red paint, we use red paint, we spray defects with red paint. Granted, that's pretty, to me, that's pretty strong evidence. And then nobody else presented. Mr. Martin said
There's
it
no
could have been,
evidence that this-
it could have been somebody else.
there's no evidence that this is the same red paint that TxDOT uses. It's just a red paint.
Correct.
Okay.
Correct. There's no testimony that it's the same red paint. However, and Mr. Chief Justice, I think that's an adequate, I mean, not an adequate, a valid line of inquiry. I would say it goes maybe a little too far to say it was a different type of red paint. And when you've got in the ordinary course of what TxDOT does is to mark defects in the road for their work is to spray paint in red. Granted, it's in the eye of the beholder sometimes, but I think it's pretty, I thought it was pretty powerful evidence to address that. As far as there are,
And a different
Yes, Your
subject real fast. Did Mr. Smithson, testify about where he fell? Did he say I fell here?
he did not. I think, he felt the death wobble.
Okay,
Right.
what evidence is there that he fell within this depressed area or adjacent to this depressed area?
There's the police officer who testified that that was his conclusion, but that was.
Police officer wasn't there though.
No.
Other than the police officer concluding. That's why I asked opposing counsel, were there any pictures of scrape marks? Apparently there were sparks going off. That means metal was contacting somewhere. Were there any pictures of that or tire marks if he was maybe hitting the brakes or something, or just to indicate where he fell?
I don't believe so. I think the testimony is he was changing lanes at that location, got the death wobble, crashed, landed further down as he sustained his injuries. The detective presumably went out and measured the length of the distances and concluded that that's where the death wobble. Is there any
detective or the officer?
I'm sorry, police officer.
Yes, the officer just assumed that's where he fell.
It doesn't show. I don't think it exactly shows, but granted, this was admitted without objection, and it was his conclusion that the uneven portion of the road caused this accident. And then you combine it with the testimony of a death wobble, which I think coincides with a motorcycle hitting an uneven.
Did the officer give any explanation to support his conclusion that this is where he fell?
No.
And I'm getting to is whether or not the officer's testimony is conclusory and no evidence, according to the Supreme Court, if it doesn't have any basis to support it.
Yes. No, other than his report shows that he went out, conducted an observation, inspected the area, was there on the scene, was able to interview witnesses and reach. And I think when you combine it with the undisputed testimony of Mr. Smithson that he hit the death wobble at that location as well. I don't think it's conclusory. I think it's quite logical that this officer is a trained accident
He
investigation.
said he hit the death wobble at that location.
Correct.
Did he say at that location, or did he just say I hit a death wobble? Did he say that I felt my motorcycle drop a little bit, or like it hit something or something, then I hit the death wobble?
No, I think he testified he was driving, hit the death wobble, but I think the testimony will show that it was at that location. I don't think it's ever been disputed that he did. I'm not aware of any evidence contradicting that the death wobble was happened at that location. I'm unaware of any. Opposing counsel may be able to point something out, but I think it was accepted at trial that that's where the location occurred.
Sounds like we were talking earlier about there were potholes and there was also a height difference.
Yes, Sean.
Where was the red paint? Just on the potholes? Was it on the height difference as well? Do we know?
No, I believe it was on the height distances. Yes, just the separation part. Yes.
It wasn't.
Not, the spray paint was not on the potholes. I could see a picture of that.
Why wouldn't Tech Stop, if they mark defects, why wouldn't they mark the potholes?
I think
If they're
they
out there
certainly-
marking defects.
I think they certainly could have. They certainly did go back and pave over the whole thing and fix it. So obviously, if you're using the red spray paint and marking the territory, that's, I would think, for workers coming out there to find the location they need to repair, and then they just paved, the picture showed they just paved over the whole area with the asphalt.
Would you just clarify your position is that TxDOT had actual knowledge or constructive knowledge?
We have taken both, given the fact that we believe it was TxDOT who put that, but if you read the jury charge, we believe it's sufficient for constructive knowledge for a couple reasons, because it's in some ways, I think, like in a criminal case, a lesser included charge. So the standard's less, but certainly based on both the TxDOT's employees testifying that they maintain it, they go out there, they travel it frequently, that they should have known about it. We contend additionally to help support that it was also TxDOT who had notice of it, which for the lower burden would give them constructive knowledge of the defect by them having put the spray paint out there and known it, but also their duty. It's a combination that both employees embraced it, that they go out there, they drive that roadway and they go out and observe those. And as we put in our brief, that TxDOT just dropped the ball on that one. They should have gone out there. They didn't do it timely enough. And Mr. Smithson suffered severe injuries as a result.
What evidence, if you can help me here, indicates or allows the jury to conclude that he hit the height difference versus hit the pothole that was not marked?
I would think, as in any accident, Your Honor, you're never going to have a complete, unless you happen to catch it on camera. Of course, cameras are so prevalent these days, it's probably happening more and more often.
Well, here's why I'm asking.
Yes.
The height difference may allow the jury to infer that they had knowledge, that the state had knowledge.
Yes.
The potholes that weren't marked, and it appeared that there's any evidence that they had any knowledge of that at all. Is it one of those arguments that if you're just within the range, then it's charged as to the whole area, or what do we do with that evidence?
I think you do. If you look at it, at least the way I decipher the cases, and I know the state will say paper says this, but when you really kind of do a survey of the holdings of the courts, it is really quite unique that you look at each situation. Like in paper, it was because it was sunken, right? And so they talk about a natural sinking, and that they could have avoided, a bicyclist could have avoided without going into the other area of traffic. So you've got that. Then you've got Reed, which is, they say because this 2-inch drop off, it's not a special defect. And then you go, a lot of the cases that we see, it's on the, and Mr. Chief Justice Quinn, there is no 3-inch rule. Okay. They're factors. And a lot of the times they're the drop-off cases, right? Where we do say, but Justice Doss, I think that's the factor. When you, at least when I read the cases, you do look at those variations. The drop-off, they seem to say it needs more of a, a factor. You need more of a drop-off because of the car coming back in. So yes, I think it goes into the mix, and I think it is a combination of an analysis. And I imagine there could be a lot of different rules that come out given the number of unique scenarios that this world can give us. Yeah. Thank you.
But.
Please, court.
Counsel.
So as your honors pointed
You
out,
argue that he hit the pothole and that since the pothole was never marked, there's no evidence of when those potholes came. Do you want to now argue that he actually hit the pothole and we didn't know about those potholes?
no, I think I'll go with the evidence, which is that there's no evidence that he encountered the potholes, and that's just what the evidence shows, whether it helps my case or not. But as your honors pointed out, a great deal of what he argues is just speculation, and a jury is not allowed to guess. This court is not allowed to guess. He has to have evidence, and he may say, well, it's really hard, in the real world, how do I get this evidence? But this is a nation of laws, and we have to follow the law.
So it's a question of law as to whether it's a special defect.
That's correct.
So are there fact issues such as the red paint and who put it there?
The
that
writ,
would-
I'm sorry.
That would go to, that the jury's entitled to resolve against the department.
Okay, the red paint has nothing to do with whether this is a special defect. That would go to other issues like the time notice rule or maybe TxDOT's knowledge. The legal issue that has to be decided is, was it a special defect? And he may talk about, oh, these cases, we got to look and mix them around. But Reed is right on point. It's an identical factual case. And they said 3 inches is not a special defect. Once they get there, even if there's knowledge, even if there's evidence that TxDOT had actual knowledge, they lose because York says, and I always like to say that was actually my case, York says that if they get the charge they want, which they did, and over my objection or a charge in proper form, and I did both, it has to be rendered, reversed and rendered. And I know there are a lot of people that don't like that, but that's what the law is. And if we don't follow the law, where are we?
Well, can we skip the special defect issue and go straight to your second issue? Is that an independent basis?
The time notice rule?
Yes.
Yeah, that's an independent basis. But before we even get there, I would like to say that their whole case is about speculation and asking the jury to guess at things. And the time notice rule, which they have made some argument to, but I don't know if I have enough time, but I would love to talk about the time notice rule and how there's no evidence to support how long it's been there, because the paint is speculation. The red line is not what he's talking about.
Well,
It's
let
paint.
me stop you for just a minute.
Yes.
Because as I understand your argument, you're saying it couldn't have been more than 3 inches deep because in the places we drilled, it wasn't more than 3 inches deep.
Well, it wasn't where we drilled, it's where their expert drilled.
Okay. That would require us to speculate about the other areas though, right?
No, that would mean that the court would have to go with the evidence it's got. It can't speculate. So the evidence it's got shows, and it's got a photo, it's got the video that shows this is even across looking down it. But if there's evidence that it was no more than 2 13/16 at all these other places, and there's no evidence to the contrary, which they have the burden to put on, then they have not met their burden of proving it's a special defect. They have that burden. I don't have to disprove it.
Does TxDOT question causation? Is TxDOT conceding that Mr. Smithson fell off this difference in level, and that's what caused the accident?
I don't think he fell off of it. I concede that.
So if they encountered it or whatever.
Yeah.
Is TxDOT saying, yes, this is where the accident happened?
I agree with that.
Okay.
I agree with that because, I mean, sure, I could say no, but I think what we have to do is a search for the truth. I mean, we've got to still be thinking about that. So I, as a lawyer, do that. I was a
I guess
little.
that's my question. What's the evidence to show that the truth is he came off this difference in height?
I don't know of any. I mean,
other than the police officer saying this is what caused it.
I don't know of any. And so I can't stipulate to that. I'm just
Okay,
saying
is
that's my guess.
Is the text dot questioning proximate cause through the argument that there's no evidence that this caused the accident?
I have not raised that.
Okay.
And I am loath to say we can sort of sovereign immunity at any time. I know that you hear
No, it's
that.
okay, I
but
just.
I don't really want to go there. I think I have a solid case here. And if I could address one point, I got 7 seconds. The duty that is, the legal duty is not something that TxDOT employees create. So whatever the TxDOT employee said on the stand does not create the legal duty. That's from the Supreme Court. Thank you very much.
Thank you, counsel. The case is submitted and you are excused to go. And again, I want to thank you for traveling up to Amarillo. And thank you for, I'm glad you had good weather today and yesterday afternoon. It was a little tough a little earlier, so hopefully that didn't impede you.
And almost at 1 o'clock last night because they canceled my earlier flight, but I got here.
Oh, okay. Go get some sleep.
Yeah, exactly.
We'll be in a brief recess.